Mr. Murali, Pillai.
Mr. Speaker, sir, I declare my interest as a disputes lawyer. The Criminal Justice Reform Bill and Evidence Amendment Bill, taken together, introduces significant reforms to keep up with the evolving needs of our criminal justice system and the larger community. The introduction of this bill follows one of the most exhaustive review of the criminal justice system in the recent history. I commend the government for involving the public and stakeholders such as the Law Society of Singapore in consultations before drawing up this bill. And we just heard the account from the Honourable Nominated Member of Parliament, Professor Madhav Mohan, who stated his involvement as a consultant to one of the stakeholders in engaging the government over several months. The strength of this bill is reflected in the consultative process that it underwent before reaching this House. I take the opportunity to comment on 3 aspects of the Criminal Justice Reform Bill and 2 aspects of the Evidence Amendment Bill. I start with the proposed amendments in the Criminal Justice Bill to community-based sentencing. As this House may recall, I had moved an adjournment motion some months ago to discuss the need for greater rehabilitative options to take into account the evolving needs of our sentencing regime, particularly for offenders suffering from mental disorders. The present proposed amendments go towards this, and I'm glad to see that my suggestion to expand community-based sentencing to offences with specified minimum sentences of fine has been taken up. As a result of these amendments, a whole new range of community sentencing options will now be open to the court dealing with such cases. I recall a recent appeal which I did before the High Court, where parties were asked to consider if a short detention order in lieu of an imprisonment term, this is a community sentence, may be imposed on a person who pleaded guilty to the offence of drink driving, causing a moderate level of harm to the person and property damage. Under the Registration of Criminals Act, a record for a crime for which a community sentence was imposed by the court will be deemed spent upon completion of the sentence. As a consequence, the person may lawfully state that he has no record of conviction. This was the case for a company director who was convicted in January 2017 in the State Court for failing to use reasonable diligence in the performance of his duties, an offence under the Companies Act. The court imposed a short detention order of 14 days on him. Upon serving the community sentence, he was able to move on with his life more easily, as his job prospects were not indelibly affected. This would not have been the case before the advent of the community sentencing regime. Returning to my case, as a minimum sentence of fine was specified in the drink driving provision, this option was not open to my client. Now, depending on the circumstances of the case, the person may be imposed a short detention order. This option will enable the court to better tailor the punishment it imposes to the culpability of the offender. It will not indelibly affect his employment prospects in the future. One further example of a community-based sentence doing good for the persons involved is a mother who was convicted for criminal intimidation against her own young children. At that point, she was suffering from clinical depression and other psychiatric conditions. She was separated from her husband. The court imposed a 12-month mandatory treatment order on her. As a result, the order allowed her to continue with her treatment, and the Child Protection Services allowed her to have supervised and subsequently unsupervised access with her children. The result of it is that she's now reconciled the children, and she's well on her way to be back on her feet. The enhanced CBS regime does not mean that we are going soft on crime. The stipulation that CBS is not available to persons who have committed serious offences for which sentences are fixed by law or prescribed by a mandatory minimum sentence of imprisonment on offence for which the sentence is fixed by law still remains. It seems to me that more resources than ever before would now be devoted to address the root causes of criminal conduct. The significant difference here is that under this enhanced CBS regime, we are in a better position to target root causes of criminal conduct by persons, especially those who have psychiatric conditions. The enhanced CBS regime will allow a wider class of persons to be subscribed to sophisticated rehabilitative programs administered by duly qualified professionals, like in the case of the mother I mentioned earlier. This will provide these persons with the best chance for rehabilitation, mend their ways, and stop reoffending. This approach better serves public interest. I wholeheartedly support the proposed amendments to expand CBS and take the opportunity to make a few comments. The present amendments do not alter the present framework in assessing an offender's suitability for a mandatory treatment order. It therefore still remains that under the Criminal Procedure Code, the suitability assessment is conducted by a psychiatrist appointed by the Director of Medical Services of the Ministry of Health. In my adjournment motion, I pointed out that there's a spectrum of mental disorders, some of which are easily treated, and others, such as personality disorders, which require sustained effort to effect improvement. However, if the appointed psychiatrist makes a guarded prognosis of the offender's susceptibility to treatment and does not recommend an MTO, the court would have no choice but to decline to make the MTO. The effect of this is that the court's determination of whether an MTO should be made is entirely reliant on the rigor and the professional opinion of the appointed psychiatrist. There is no mechanism for the court to scrutinize the opinion of the appointed psychiatrist, for example, by reference to other independent psychiatric evaluation that the offender may have obtained, or through defense counsel's cross-examination of the appointed psychiatrist. This approach is divergent from the approach taken in the context of reformative training. Under the CPC, before an offender may be sentenced to reformative training, the offender would need to be assessed to be suitable for reformative training by a Singapore Prison Service psychiatrist. In a parliamentary question that I filed earlier this year, I asked the Minister for Law whether he would consider expanding this requirement to allow for an independent report from a court-appointed psychiatrist. The Minister's response was that the Singapore Prison Service psychiatrist is a professional who is familiar with the reformative training regime and will make his or her independent assessment of the offender. The Minister further highlighted that the court may, if it deems necessary, direct the SPS psychiatrist to be cross-examined, or that further expert evidence or second opinion be obtained, including from a court-appointed psychiatrist. This being the case for reformative training sentences, it is, with respect, incongruent that for MTOs, the court determination is constrained by the sole professional judgment of the appointed psychiatrist. I personally dealt with a case where a psychiatrist issued an opinion supporting an imposition of an MTO on my client who was suffering from an anti-personality disorder, which I understand requires intensive inpatient treatment for a significant period of time. This opinion was used to persuade the court to call for a suitability assessment for an MTO. The same psychiatrist was then appointed by the director and later on he issued a diametrically opposed opinion without providing sufficient explanation for the change in opinion. The court was not in a position to look beyond the second opinion based on the current provisions. Second, a point that I've raised in my adjournment motion was the approach taken to determine if an offender is treatable and therefore suitable for an MTO. Then I had highlighted that the UK has moved from a treatability test towards an appropriate treatment test when considering sentencing orders for offenders with mental disorders. The new test allows the UK courts to make a detention order for treatment as long as, having regard to the nature and degree of the mental disorder and all other circumstances, the appropriate medical treatment is available for the offender. As I recall, the Ministry of Law agreed to study my proposal, which, if accepted, would have the potential of extending MTOs to offenders who require more intensive treatment and rehabilitation regimes to cope with their psychiatric conditions and overcome their offending behavior. I wonder if there's any landing reached on this study, please. Next, another area of note is the proposed regulation of the use of psychiatric evidence in criminal proceedings. The use of psychiatric evidence is an area of expert evidence that has seen some of the greatest growth in recent years. The proposed amendments will require psychiatrists to be admitted to a court-administered panel of psychiatrists before they are allowed to give expert evidence in court. I do not see this amendment as singling out psychiatrists for stricter regulation than other types of expert witnesses. All experts must give evidence in an objective and professional manner. On the contrary, the amendment recognizes the prominent role that psychiatrists play in the criminal justice system. Because so many cases turn on psychiatric evidence, it is important to ensure that such evidence in form of opinions presented in court is objective, well-researched, and professional. In view of the frequency with which psychiatric evidence is admitted in criminal cases, establishing a court-administered panel is, in my view, a very good way to regulate such evidence. Could the Honorable Senior Minister of State please clarify whether it is contemplated that there will be a fixed quota of psychiatrists who are admitted to the panel? Apart from the psychiatrists being qualified and having relevant work experience and character references, are there any other factors that the selection committee will take into account in determining whether to admit a psychiatrist to the panel? I now move to another area of amendment to the CPC relating to the admissibility of statements taken by the CPIB as evidence in non-corruption offenses. Section 27 of the Prevention of Corruption Act requires a person to be being interviewed in relation to offenses under the PCA to give all information he's asked to give. In contrast, for non-corruption offenses, Section 22 of the Criminal Procedure Code preserves a person's right against self-incrimination by requiring a person giving a statement to the police to state what he knows of the facts and circumstances, except that he need not say anything that might expose him to a criminal charge, penalty, or forfeiture. At present, a statement given under Section 27 of the PCA is inadmissible in relation to non-corruption offenses. This preserves the right against self-incrimination that is provided for in the Penal Code. However, the proposed amendments to Section 258 of the CPC will change that, such that statements given to the CPIB under Section 27 of the PCA may now be relied on in non-corruption offenses, when ordinarily, if the statement were made to the police, the right against self-incrimination would be preserved. It will always be the case for a person giving a statement to the CPIB under the PCA to be legally obliged to say more than he would ordinarily say if interviewed by the police in relation to a non-corruption offense. I'm struggling to identify a principled basis to preserve the right against self-incrimination in relation to non-corruption offenses, which include serious white-collar crimes such as criminal breach of trust as an agent, while at the same time abrogating the right if the statement was originally given in relation to a corruption offense to a CPIB officer. In my view, the abrogation of the right against self-incrimination for PCA offenses under Section 27 of the PCA may be justified by reason of the nature of the corruption offenses. At one level, these offenses can be seen as victimless crimes because both the briber and the person receiving the bribes are likely to cooperate with each other and keep their conduct under wraps. This makes such offenses much more difficult to investigate. Hence, the abrogation of the right against self-incrimination will allow the CPIB to be more effective in its investigation to tackle corruption. However, it's a different ballgame when the statements are used against the person for a non-PCA offense for which he would otherwise have a right against self-incrimination. Could the Honourable Senior Minister of State please clarify what is the policy and rationale behind this dichotomy in treatment? Third, the Criminal Justice Reform Bill introduces the Deferred Prosecution Agreement regime, which allows the prosecution to enter into an agreement with the accused corporation to agree not to prosecute in exchange for compliance with a series of conditions such as payment of a financial penalty on appointment of a person to assess and monitor the corporation's internal controls. The contemplated DPA regime requires that DPAs are approved by the High Court and allows for the prosecution and corporation that is subject of the DPA to make submissions before the court makes its determination. I noted earlier that the Honourable Member, Ms. Sylvia Lim, expressed concern that the High Court making this determination sits in camera. I felt that sitting in camera actually strikes a proper balance, because at that point in time, the court would not have made a determination whether or not to sanction the DPA. So there's always a possibility that the case may still go on and the corporation be prosecuted. So in those circumstances, to make a pronouncement on what has happened in the proceedings, maybe sub judice, may even affect prosecution of the offenses. So I felt that the balance struck in the bills by allowing the public prosecutor in a situation where the High Court gives its approval to make a public notice outlining the reasons for the High Court's decision is a good one. In this regard, the persons acting on behalf of the company in respect of the DPA would typically be the board of directors appointed by the shareholders to act on behalf of the corporation. However, given that DPAs may have an impact on shareholder interests in the corporation, there may be times when shareholders' interests may not be aligned with the position taken by the directors on behalf of the company, especially when the company is asked to pay fines of substantial sums. The present DPA regime does not appear to allow for the intervention of such interested parties at the hearing by the court to determine whether or not to approve the DPA. Would the Honourable Senior Minister of State please clarify that the provisions do not preclude the court from allowing interested stakeholders to join in the proceedings so that it is in a position to properly consider the interests of all relevant stakeholders or parties before approving the DPA. As mentioned earlier, the DPA may provide for an appointment of an external monitor to monitor the corporation's implementation of internal controls under the DPA, or remediation, as the case may be, and to report to the prosecutor any misconduct in the implementation of internal controls. It is common in DPAs entered into with US authorities for such external monitors to be appointed at the corporation's expense, even though the monitor is in reality working for the prosecuting authorities. This structure has the potential of giving rise to a moral hazard in that the external monitor may have a financial interest in having an expanded scope of work. I've seen real-life examples of this. I've seen examples of monitors tying up the corporation's business in knots, especially when the scope of monitoring has not been precisely determined and agreed in the DPAs beforehand, and submitting bills to corporations running into millions of dollars per month. While the contemplated DPA regime provides that the monitor is to report to the prosecutor any misconduct in the implementation of the corporation's internal controls, it is not clear who has control over the monitor. I wonder if there's any intention to provide in the DPAs that the monitors be subject to oversight by the court, akin to the position of liquidators appointed in the winding up of companies. This would repose monitors with duties owed to the court and ensure that his or her professional fees are fair and that the work done was properly within the scope of appointment under the DPA. I now turn to the proposed amendments to the Evidence Act. The proposed amendments seek to enhance the protection for victims of sexual or child abuse, to reduce the stress they may face in the criminal justice process. Other countries have taken similar actions to protect victims of sexual offences from intrusive questioning in court. For example, in the UK, Section 41 of the Youth Justice and Criminal Evidence Act imposes a general prohibition on the admission of evidence or questions in cross-examination relating to a sexual history of a complainant, save in narrow exceptions, such as where the evidence is necessary to rebut prosecution evidence. However, even where one of the exceptions are met, the judge must be satisfied that further criteria are met, such as the purpose of the evidence is not to impugn the complainant's credibility, and the evidence is required to ensure a fair trial. The UK process requires the defense to obtain the court's permission to introduce such questions or evidence about the complainant's sexual history by way of an application made to court within a specific time frame according to requirements set out in the UK criminal procedure rules.
Sir Pillai, you have half a minute to wrap up.
Yes. In our case, the proposed section 154A of the Evidence Act provides that the minister may make rules to restrict the questions that may be asked of an alleged victim of cross-examination. I support these objectives. However, I wish to seek some clarification. Given that the Evidence Act already contains restrictions on certain kinds of questions, What is the rationale of having these restrictions dealt with in secondary legislation instead of primary legislation? As I pointed out, even the UK model...
Kindly wrap up, please.
Yes, sir. Just... Right, so just this last question.
You don't have time for a last question.
Yes, I think I'll
Thank you
stop
very
here, sir.
much.
I'll take your cue.
Mr. Desmond Chu.